You're listening to the Quint podcast.
Is sedition law still needed after 75 years of independence? CJI NV Ramana's question to the centre has once again revived the debate on whether it's time to review this law that comes from India's colonial era. This observation came up in a hearing on a plea challenging the constitutional validity of Section 124A of the IPC. As CJI Ramana raised the concern of the misuse of such a law, Attorney General K.K. Venugopal said that the court could just put down guidelines instead of scrapping the law. But just like the UAPA cases, even sedition cases have risen in the past few years, despite the conviction rate remaining under a meagre 3.3%. While the centre has been constantly accused of slapping such a charge against citizens to quell dissent, many lawyers, activists and other members of the civil society have been saying that the sedition law needs to be struck down. So what are the arguments against sedition law? Is it being misused by the state, and is it time for it to be scrapped? My guest in this episode is Naveed Mahmood Ahmed, a research fellow at Vidhi Centre for Legal Policy. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shorburi. The constitutional validity of the sedition law has been often questioned, especially because this law was expressly used by the British Raj to suppress dissent and the struggle for independence. The fact that it can or has been misused was something that even the Supreme Court noted recently. A bench headed by CJI Ramana is currently examining two pleas filed by the Editors Guild of India and a former Major General, which challenged the constitutional validity of Section 124A in the IPC. And on 16th July, the top court made some sharp observations. Asking whether such a law is needed right now in India, the court said that the sedition law has been enormously misused. To quote a line from the Supreme Court bench's observation, they said, quote, "It can be compared to a carpenter asked to cut a wood, cut the entire forest," end quote. But before we talk more about how this law can be dangerously misused and why it needs to be scrapped, what defines sedition exactly? Under Section 124A of the IPC, sedition is defined as an offence when, quote, "any person by words, either spoken or written or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India," end quote. And disaffection here includes disloyalty and all feelings of enmity. But comments without exciting or attempting to excite hatred, contempt or disaffection don't constitute as an offence under this section. Sedition is a cognizable and non-bailable offence which could lead to a life imprisonment with or without a fine. But another way to look at this law is that it has been muffling dissent in India since the 19th century when Thomas Babington Macaulay drafted it in a bid to suppress disaffection against the British Raj. And CJ Ramana also pointed out that this same law was also used against Mahatma Gandhi and Bal Gangadhar Tilak in colonial India. So then why did such a law survive well after independence at all? Naveed Mahmood Ahmed, a research fellow at Vidhi Centre for Legal Policy, explains how the sedition law made its way to modern India.
In the Constituent Assembly, while debating the provision guaranteeing freedom of speech and expression and the reasonable restrictions imposed on it, the issue of sedition did come up. And this was because the initial draft categorized sedition as one of the grounds on which free speech and expression could be restricted. And this was in addition to slander, morality, decency. An amendment was moved to drop the word sedition from this, and during the debates on this amendment, it's used against the leaders of the freedom movement was underlined, just as it is being done now. It was also pointed out how even meetings and processions have attracted the law, and even holding an opinion that may bring the government, that may bring ill will against the government, has attracted the law of sedition. K.M. Munshi had a very strong argument against it, and he did highlight that in practice, the law is misused primarily because it is construed very widely. He also stated that the public opinion has changed, and now that there is a democratic government in place, and therefore a line needs to be drawn between criticism and incitement. But even though we dropped sedition as one of the grounds of imposing restrictions on free speech, we did retain it in the IPC.
Now, even though in the year 1962, the Supreme Court had read down Section 124A and had said that for an act to be seditious, there must be an incitement to violence, This law has been repeatedly used against citizens, often on very flimsy grounds. And just to point out some of the recent instances when sedition charges were applied on a flimsy basis, only earlier this year, a 22-year-old climate activist, Disha Ravi, was slapped with sedition charges in connection to a toolkit relating to the farmers' protest. Well, the trial court granted her bail, observed that, quote, sedition cannot be invoked to minister to the wounded vanity of the government, end quote. Both the Delhi police and the centre faced sharp criticisms. Or rewind to 2020 when more than 60 students in Karnataka aged between 9 to 11 were interrogated at least 4 times by the police in 1 week for participating in a play that was critical of the citizenship law. And on the basis of a complaint made by an ABVP activist who had found the play to be seditious, a single mother and the school principal were arrested. And again, the district court dismissed those charges, but the police drew a lot of flack. But just to get an idea of how often this charge has been used in the past years, Article 14, which is a news and research website maintained by lawyers, journalists, and academics, found out that there's been a 28% increase in the number of sedition cases filed each year under Modi's term between 2014 and 2020. And a lot of such cases were filed in violation of the Supreme Court guidelines. There were also a spate of sedition charges over the anti-CAA protest, around 25 of them to be precise. 6 sedition cases were filed in the course of the farmers' agitation, 22 after the Hathras gang rape case, and 27 after the Pulwama terror attack. But what is important to note is that the NCRB data itself says that till 2019, the conviction rate in sedition cases was at a mere 3.3%. But if the convictions are so low, then what is the validity of such an archaic law? Mr. Ahmed says that despite the low conviction, the process itself is punishment.
Generally, conviction rates are seen as success of the prosecuting agencies and the criminal law in general to show that the law is identifying and punishing problematic behavior. In this case, it would mean that the law identifies and punishes acts that bring the government into hatred or contempt or excited disaffection towards it. But with laws like sedition under the IPC and many other preventive detention laws, or say the UAPA, it seems that the system is aware that you don't need a conviction because the process itself is the punishment. While NCRB data clearly shows that conviction rates in sedition cases is at around 3%, there is a pendency of 74% before the courts, and there is also delay in completing the investigation and filing of charge sheets. So the problem with the law is the intention with which it was drafted, and this is reflected in the way it is written. The way the law is written provides sufficient room for prosecuting agencies to arrest, to urge for denial of bail, and essentially to drive the trial. Vague terms used in the provision like disaffection allow the police to use it in all sorts of situations, and by the time it is proved that whatever was said or done did not fall within the purview of sedition, the person would have spent quite some time in prison as an under trial.
Now, a big reason as to why there have been so many calls to scrap the sedition law is because there have been allegations against the government for using or rather misusing the UAPA and the sedition laws jointly to stifle any kind of criticism and free speech. In a few of our previous episodes of The Big Story, we've also covered how the dreaded UAPA charges have been used against activists, scholars, and others to often clamp down on dissent against the government. You can find the episodes on our show notes, but speaking of sedition charges, Article 14 points out some interesting factors. A whopping 96% of sedition cases that were filed against 405 Indians for criticizing politicians and governments in the last decade were registered after 2014. And 149 people of that 96% were charged with sedition over making quote-unquote critical and or derogatory remarks against Modi, while 144 people made critical comments against UP Chief Minister Yogi Adityanath. While it's quite a big deal for the Supreme Court to be asking if we should continue with such a law and to revive the discussions on whether the law needs to be scrapped finally, does it make a real difference until the law is actually struck off? Back to Mr. Ahmed here.
Although we often say that it is a colonial legacy and therefore it must go, it is important to recognize that all governments in power for the past 7 decades perhaps have felt the need for it and therefore have used it. The CJI's observations are certainly important in reviving the debate, but such observations have come before also. And a few weeks ago, the Supreme Court said that it was time to define the limits of the law. And even other than that, the Supreme Court has on a few occasions tried to limit the application of the law to acts that incite violence or create disorder, and therefore they've tried to limit the scope of the law and address the vagueness. But I feel unless the law is scrapped, it will continue to be misused. It will keep pushing people into the criminal justice system for the mere expression of their beliefs. And more importantly, it will continue to have a chilling effect on free speech.
And that's a wrap for this episode, but do visit the Quint website and check out our other podcasts. If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.